Welcome to the Golden State Real Estate Quest, where we turn daunting exam topics into clear pathways to success. Imagine for a moment you're helping Sarah and Tom, a young couple, secure their very own slice of the California dream home. Maybe it's that perfect beachfront condo in Malibu, or, a vineyard up in Napa, maybe a tech hub home in Silicon Valley. They've got the vision, they got the financing all lined up, and they're so ready for those keys. But what does owning truly mean? I mean, really mean, beyond just having that deed in hand? Is it just about possessing a piece of paper, or is there, more to the story, more hidden beneath the surface of that dream home?
That's a really profound question, actually, and one we'll definitely be tackling today. Too often, people think ownership is just, the physical house or the plot of land. But in the, let's say, intricate world of California real estate, the whole concept of property ownership is built on these fascinating layers: legal definitions, historical context. It's almost like a complex geological formation that reveals its history the deeper you dig.
Well, I like that analogy, geological formation, yeah. Today, we're diving deep into exactly that, the fundamental building blocks, the hidden foundations, you could say, of property ownership right here in the Golden State. Think of it like understanding the bedrock beneath that dream home Sarah and Tom are looking at. We're going to explore the really crucial distinctions between real property, the land and what's permanently stuck to it, and personal property, which is basically everything else. Then we'll uncover how multiple people or even entities can hold ownership together, which, wow, has huge implications for things like inheritance. And maybe most importantly, we'll pull back the curtain on those invisible claims that can seriously impact a property, things like easements, liens, restrictive covenants, stuff you might not see at first glance.
Right. And understanding these seemingly complex legal terms isn't just about passing your exam, though. Let's be clear, it will definitely help you ace it. It's the absolute bedrock, as you said, of a successful, ethical, and frankly, headache-free real estate career. Knowing these nuances empowers you. It lets you guide clients like Sarah and Tom effectively, anticipate potential issues before they blow up into major problems, and ultimately it fosters that deep trust in your professionalism, your ability to explain these layers. That's what really transforms you from just a salesperson into a truly trusted advisor.
Okay, so let's unpack this. Let's start with a very basic question. What is property, really, in the eyes of California law? And how do we make that first big split between real and personal?
Well, to really get the modern picture, we actually have to take a quick trip back in time, a little detour to English common law, but it's enlightening, I promise. You see, historically, the word property didn't actually mean the physical thing being owned, not the house, not the land, not the car. Instead, it referred specifically to the rights an owner held in that thing. It's kind of an abstract concept, famously called the bundle of rights, or sometimes the bundle of interests.
Huh. So less about the actual bricks and mortar of a house and more about what you could legally do with it. The power, the control, the privileges that came with owning it. That's actually a pretty big philosophical difference.
Exactly, you nailed it. And this bundle, well, it was pretty comprehensive. It included fundamental rights like the right to possess the property, obviously, the right to use it however you saw fit, the right to encumber it, which means, put a financial claim against it like getting a mortgage, the right to transfer it, sell it, give it away, and crucially, the right to exclude others from it. That last one, the right to exclude, is still seen as one of the most fundamental parts of private property ownership today. The early English courts even had different kinds of lawsuits based on what you could get back if your rights were violated. If a landowner was, say, wrongfully kicked off their land, they could bring a real action to recover the land itself, the actual real thing. And that's exactly where the term real property came from.
Okay. And if you could only get money damages, not the actual item back, that was a personal action, which then led to personal property.
You've got it precisely. That's the historical root. And this distinction carried over into what they called estates in land. A freehold estate was considered an ownership interest that lasted for an indefinite duration, meaning it wasn't for a set number of years, but could potentially last forever, or at least for someone's lifetime. These were seen as, superior interests, not tied to the demands of some feudal overlords, and they were classified as real property. Examples would be an estate in fee or a life estate. Now, in stark contrast, you had less than freehold estates, like a tenancy or a lease. These had a specified limited time, maybe a month, a year, 5 years. And interestingly, even though they related to land, they were treated as personal property.
So a freehold estate sounds like the ultimate ownership, the top tier. What was the most complete one you could get back then?
The biggest, most complete estate known to law was, and actually still is, an estate in fee simple absolute. This essentially gave the owner the most comprehensive bundle of rights possible over the property. Full control over what happens to it. They could sell it, gift it, or even pass it down through their will when they died without any conditions or limits attached. It's really the closest thing we have to absolute ownership, giving the holder pretty much all the rights in that bundle.
But I've heard about situations where there are conditions attached, even to these fee simple estates. How does that work? Is that something an agent needs to worry about today?
Oh, absolutely. That brings us to what's called a fee simple defeasible estate. This is where the ownership, even though it seems absolute, can actually be defeated or terminated if a specific condition isn't met or if some event happens or doesn't happen. So imagine original grantor A sells a property to grantee B, but sticks a very specific condition in the deed. The property must always be used as, say, a hostel for traveling musicians. Weird example, maybe, but possible. Now, Sarah and Tom find this place, love the location, but they plan to turn it into a quiet family home. If B, or even Sarah and Tom years down the line, were to change that use, the original grantor A, or maybe their heirs, could potentially come back, re-enter the property, and terminate the estate. They could actually reclaim ownership. So it's an ownership interest, sure, but it's qualified by that condition. The real takeaway for you as an agent is understanding that some properties come with these invisible, long-standing strings attached. These conditions, even decades later, could potentially undo the ownership if they're violated. That makes a thorough title review absolutely critical for your buyer's long-term security. It's not just a quirky historical thing, it's a potential real-world risk.
Wow, yeah, that's potentially pretty alarming. Okay, what about a life estate? How's that different from fee simple, even the defeasible kind?
A life estate is another interesting type of freehold interest. It's created when a grantor gives property to someone, let's call her B, but only for the duration of B's life. Or sometimes it could even be for the life of another specified person, say C. The interesting part is what happens after B or C dies. The original grant usually dictates who gets the property then. So B has full possession and use during their lifetime, but they don't get to decide who inherits it. The original grantor already set that up. It's considered freehold because its length isn't fixed in years, but tied to a life. It grants significant rights, but only for a finite, though undefined, period.
Okay, so that covers the historical bundle of rights and how these different estates came about. Now, fast forward to today. What's the modern view of property in California? How do we define real property now, maybe in simpler terms?
Yeah, in the modern view, we simplify it a bit. We move away from focusing just on the rights and more towards the thing itself. Property is now commonly thought of as the thing owned, and it's categorized simply as either real or personal. Here in California, real property basically consists of four main components. First, the land itself. Second, anything affixed to it and seen as a permanent part of the land. Third, anything that's incidental or appurtenant to the land. And fourth, anything that is simply immovable by law.
Let's break those four down, starting with land. Seems straightforward, but I bet it's more than just the dirt on top.
Oh, much more. Land isn't just the soil, rock, and other stuff on the surface. It also includes the space beneath it, theoretically going all the way down to the center of the earth. And maybe surprisingly, it includes the space above it, theoretically stretching up to the top of the sky.
Wait, hold on. To the top of the sky. So if Sarah and Tom own land, they own all the air above it. What about airplanes flying over? Doesn't that kind of contradict that idea?
This is where it gets really interesting and practical, right? While traditionally, yes, property rights went up to the heavens, modern courts have recognized a crucial public right. The airspace above private land is seen as a kind of highway available for public use. This is totally fine as long as that use doesn't unreasonably interfere with the landowner's enjoyment of their property. So, airplanes flying way overhead. Generally, that's not infringing on your property rights unless they're, buzzing your house really low, making excessive noise, or posing a direct safety hazard. Then it might become a nuisance.
Okay, that makes sense. And what about underground? I know oil and gas rights are a big deal, especially here in California.
Ah, yes, subsurface rights. They're fascinating because things like oil and gas are fugitive. They can move around underground. Landowners have a valuable right to drill vertically down into their own land to capture these resources. However, and this is a critical point, that right does not allow you to drill slantwise under your neighbor's land to get oil or gas over there. Doing that would be an encroachment, a trespass, because you're physically invading their property boundaries below ground. So you own what's directly under you, but you can't just reach into your neighbor's underground bundle.
Got it. Land is definitely more complex than just dirt. Okay, second component. Anything affixed and regarded as a permanent part of the land. This is where fixtures come in, isn't it?
Precisely. This is about items that were once personal property, movable things, but have been attached to the real property in a way that makes them considered part of the land itself. Think big things like buildings, bridges, even natural things like trees and permanent landscaping. But it also includes things permanently attached to those structures. So the doors on a building, built-in kitchen cabinets, a water heater, built-in appliances like a wall oven, these are all examples. Because of how they're attached, they become part of the real property. The key things here are the permanence of the attachment and the intention behind putting it there.
And the third category, that which is incidental or appurtenant to the land. What does appurtenant mean here? Sounds very legal.
Appurtenance is a legal term, yeah, but it's super practical. It basically refers to something that legally belongs to another larger, more valuable thing, in this case, the land, and it passes along with the property when it's sold. It's essentially a right or privilege that runs with the land, benefiting it. Think of natural water courses or easements, those rights of way that let you cross adjoining lands to get to yours. Even things like passages for light, air, or heat that come from or cross a neighbor's land can be appurtenant. They're rights that add value and usefulness to your property.
Can you give a really specific, maybe even surprising example of something often appurtenant here in California?
Sure. A classic California example is stock in a mutual water company. In lots of agricultural or semi-rural areas, homes get their water from these companies, right? If the stock certificate specifically says it's appurtenant to the land, that means ownership of the stock, and therefore the right to get water, cannot be sold separately from the land. You can't just sell off your water rights. They are fundamentally tied to that specific property, boosting its value. This is a huge deal in water-scarce areas, obviously.
So how do courts or even agents trying to solve that fixture dilemma decide if something is really appurtenant or a fixture? There's specific tests they use besides just seeing if it's bolted down.
Yes, there are several key tests that courts look at, and smart agents use these same ideas when advising clients. First, there's permanence. Was the addition meant to be a permanent part of the property or just temporary? Second, the method of incorporation into the land, how permanently is it attached? Like an in-ground swimming pool cemented in, definitely an appurtenance. An above-ground pool, probably temporary personal property. Third, the adaptability of the item for the property's ordinary use. Is it custom built for that space? Is it essential for how the property functions? If it fits perfectly and seems necessary, it's likely a fixture. Fourth, the existence of a clear agreement between the parties. This is huge. A clear contract can totally override assumptions. And finally, that fifth component of real property is just anything immovable by law. Kind of a catch-all for stuff legally defined as real property, even if it doesn't perfectly fit the other descriptions.
Okay, let's hit a CA corner that's super practical for agents. Fixtures and how they're handled in the California Residential Purchase Agreement, the CAR form RPA. What does that form actually say about what usually comes with the house?
Right. This is where the abstract definitions meet the reality of negotiations for Sarah and Tom. The CAR form, specifically paragraph 9b, gives a pretty detailed list of common items that are included as existing fixtures and fittings attached to the property unless the seller specifically excludes them in writing. The list is pretty long, trying to head off disputes. It includes things like existing electrical, mechanical, lighting, plumbing, and heating fixtures, ceiling fans, fireplace inserts, and all built-in appliances. Think your dishwasher, wall oven, cooktop. It also covers window and door screens, awnings, shutters, and all window coverings, blinds, curtains, the rods they hang on.
So basically, if it's built in or attached pretty firmly, it's a safe bet it stays.
Generally, yes, and the form aims to make that the default assumption. The list goes on. Attached floor coverings, TV antennas, satellite dishes, air coolers, conditioners, pool spa equipment, including the creepy crawly cleaner, heater, covers garage door openers and remotes, mailboxes, even things that set the mood, like in-ground landscaping, water features, fountains. Crucially, it includes water softeners, water purifiers, even light bulbs, including smart bulbs if they're physically attached. And in today's world, smart home features like thermostats and lighting systems connected to a control unit are included if they're physically affixed.
That's a really thorough list. But what about things people might think are included, but the CAR form clarifies or not? Those seem like potential arguments waiting to happen.
Good point, because yeah, these cause confusion. The form also lists important exclusions. For example, non-dedicated personal computers, tablets, or phones used for smart home control, usually excluded. They're personal items, not fixtures. Also, audio-video components, like that big flat-screen TV or speakers. Excluded if they aren't themselves attached, even if the wall mount or brackets are attached. The TV itself is personal property. And interestingly, furniture and other items secured for earthquake or safety purposes are also typically excluded. Their attachment isn't about making them part of the real estate, it's about safety.
That's a critical detail, especially here in earthquake country. It really drives home how important it is for sellers to spell out what they're taking and for buyers to know exactly what they're getting. And the form also says sellers represent the included items are owned, transfer-free of liens, and without seller warranty, usually.
It's correct. It's standard buyer protection, though exceptions can be negotiated. Sellers should also cooperate in identifying any software or apps and helping transfer services needed to run smart home features or other included items. It's about handing over functionality, not just the physical thing.
This leads perfectly into a classic think like an agent situation. Imagine your seller client. They spent years perfecting their home, and they have this amazing custom-designed, permanently installed wall unit. It matches the living room perfectly. They love it, want to take it. But then Sarah and Tom, the buyers, see it, assume it's a fixture, and fully expect it to stay. How do you, the agent, navigate this fixture dilemma and stop the deal from blowing up over furniture?
Oh yeah, this is a classic scenario. It can cause real grief if you don't handle it right, and it happens more than you'd think. As the agent, you got to be proactive. You need to understand those 5 tests the courts use for fixtures to guide your clients. Test 1 is the intention of the person who installed it. Did the seller mean for it to be permanent or just temporary? This can be tricky to prove, but their actions or maybe even written statements can matter. I actually remember a case where intention was key because the seller had specifically listed a very expensive custom wine cellar as personal property in their family trust docs way before selling. Even though it looked permanent, that prior documented intent really muddied the waters for the buyer.
So even if it looks permanent, if the seller can show they never intended it that way, that actually matters.
It's one crucial factor, yeah, among several. The second test is the method of incorporation. How permanently is it attached? Something stuck in with cement and plaster or wired right into the house. Much more likely a fixture than something just resting on the floor or held by a couple of screws. Third, the adaptability of the item for the property's normal use. Is it custom built for that exact spot? Is it essential for how the property functions? If that custom wall unit is built into an alcove, designed just for that living room, it seems pretty adaptable to that property's use, right?
Makes sense. And the 4th and 5th tests.
Fourth is the existence of a clear agreement. This is where you, the savvy agent, really earn your stripes. If there's a clear written agreement in the purchase contract about that item, say, explicitly stating wall unit in living room excluded from sale, then its status probably won't be an issue. Finally, the 5th test is the relationship between the parties like seller-buyer versus landlord-tenant, buyers and lenders inspecting a property. They're usually justified in assuming that what's attached and looks essential for the property's use is part of the deal.
So the huge takeaway here is, write it down. If the seller wants that wall unit, exclude it specifically in the contract. And if Sarah and Tom absolutely love it, they need to make sure it's specifically included.
Precisely. Any exceptions need to be crystal clear in the contract to avoid fights later. Manage those expectations right from the start for both sides. And speaking of tenants, there's a special rule for them with fixtures, isn't there?
Yes, there is. A tenant can generally remove items they've attached, often called trade fixtures, for purposes of their trade, manufacturing, decoration, or domestic use. They can do this as long as removing it doesn't cause substantial damage and the item hasn't become like an integral, unremovable part of the place. This is another common point of argument, so it's good to know about that tenant exception. Good point. Now, let's quickly define personal property since we focus so much on real property. What actually counts as personal property in a real estate deal?
Personal property is basically the leftovers category. It's any property that is not real property. This covers a huge range of stuff. It includes things like money, movable goods, or chattels, so furniture that isn't built in, cars, jewelry, clothes. It also includes evidences of debt, like promissory notes, and even something more abstract called choses in action.
Choses in action? Wow, that sounds really legalistic. What does that mean for us?
It's just a fancy legal phrase for the right to recover money or other personal property through a lawsuit. For instance, if someone owes you money on a promissory note, your right to sue them to collect that debt. That's a chose in action. Or if you get injured due to someone's negligence, a tort your right to sue for damages is also a chose in action. The main things about personal property are It's movable, often short-term or consumable, usually easy to transfer, and generally it depreciates in value over time, unlike real property, which often appreciates.
Okay, so a car is personal property, but the garage it's in and the land in the garage, that's all real property. Pretty clear distinction then.
Exactly. And even some crops can be personal property. A tenant's annual crops, sometimes called emblements, or industrial crops that need annual planting and harvesting, those are treated as personal property. Also, things attached to the land, but specifically agreed to be severed before the sale or under the sales contract, those are treated as goods personal property, even if they were still physically attached when the deal was made.
It's really clear there's a fundamental split between real and personal property. What are the key legal differences that aspiring agents absolutely need to get because they really impact how we advise clients?
Yeah, there are a few critical legal differences with major practical effects. First, the statute of frauds applies very differently. Agreements for selling real property. They pretty much must be in writing and signed by the person being charged, usually both parties, to be legally enforceable. That's why your purchase agreement is always a written contract. But for personal property, under the Uniform Commercial Code, an agreement only needs to be in writing if its value is over $500. Below that, an oral agreement can actually be binding.
Wow, that's a big difference in threshold. So much for handshake deals in real estate, huh?
Definitely not. Second, there's a difference in governing law. The laws of the situs state, meaning the state where the real property is physically located, govern how title is transferred. So, if Sarah and Tom buy a house in San Jose, California law applies, even if they currently live in New York. Commercial sales of personal property, though, are usually subject to broader federal and state laws, often the Uniform Commercial Code, which is pretty similar across states. Third, real property has a formal, state-provided recording system, at the county recorder's office where documents affecting title are filed. This system is crucial for proving ownership, giving public notice, and protecting against conflicting claims. Generally, there's no such formal public recording system for personal property. Ownership is often tracked by private registries or just by who possesses it.
And finally, I'm guessing taxes are handled differently too, which can be a pretty big deal for owners.
You're absolutely right. Tax laws often treat real and personal property very differently. Real property is usually subject to annual property taxes based on its assessed value, like Proposition 13 here in California. Personal property, on the other hand, generally isn't subject to recurring property taxes for individuals, although businesses might pay taxes on certain types of business personal property. Understanding these legal differences is really vital because they affect everything from contract validity to financial obligations and potential risks for your clients.
Okay, that was a great deep dive into what property is. Now let's shift gears to who holds the keys. For Sarah and Tom, buying their first place, how can property actually be owned in California?
Right. Every single piece of property, whether it's a huge ranch or a tiny condo, has an owner. That owner could be the government, or it could be a private person or some kind of entity. And the way they choose to hold ownership, that's usually a very deliberate decision. It's based on their needs, their financial goals, their plans for the future, especially things like inheritance or how a business operates. Very broadly, real property can be owned a few main ways: by one person in sole ownership, by several people together in various forms of joint, common, or community ownership, or by legally created entities like partnerships, corporations, or maybe even land trusts.
Let's start simple. Sole ownership. What are the key features of that?
Sole ownership, sometimes called severalty ownership, is just what it sounds like. Ownership by one single person or one single legal entity like a corporation. As the sole owner, that person gets all the benefits from the property, all the income, all the use, all the control. But they also carry all the burdens alone: taxes, maintenance, any liabilities. They're generally free to do what they want with it, sell it, gift it, mortgage it, without needing anyone else's okay. And usually, only the sole owner's signature is needed on the deed or transfer documents. It's straightforward, but it also means all the responsibilities on them, and if they die, the property typically has to go through probate court.
So one person, total control, total responsibility. What happens when multiple people, like our couple Sarah and Tom, want to own a property together? That's concurrent ownership, right?
Yes, exactly. Concurrent ownership or co-ownership just means simultaneous ownership of a property by several people, two or more. This is super common, especially for married couples, business partners, family members buying together. The main types you'll run into are tenancy in common, joint tenancy, and crucially here in California, community property.
Let's start with tenancy in common. What defines that? How might Sarah and Tom end up owning their home this way?
Okay, Tenancy in common exists when two or more people own undivided interests in the title to real property. The interests don't have to be equal, but their ownership is in the whole property, not just a specific physical part. It's kind of the default. It gets established automatically if the deed transferring property to two or more people doesn't specifically say joint tenancy, partnership, or community property. For example, if a deed just says to Sarah and Tom and they're not married or specified otherwise, they'd likely be tenants in common by default. Of course, the deed can also spell it out clearly, like to Sarah and Tom as tenants in common.
And what's the really critical difference there, especially when it comes to inheritance? I remember hearing something about right of survivorship not being part of it.
That is the single most important characteristic and why getting this right is so crucial for your client's estate planning. With tenancy in common, there is no right of survivorship. This means if one tenant in common dies, their share of the property does not automatically go to the surviving co-owners. Instead, it passes directly to their beneficiaries, whoever they named in their will, or their legal heirs if they don't have a will, and it usually has to go through probate court first. The heirs basically just step into the shoes of the person who died and become tenants in common with the remaining original owners. So, if Sarah and Tom owned as tenants in common, and sadly Sarah passed away, her share wouldn't automatically go to Tom. It would go to whoever Sarah designated in her will, maybe her kids from a previous marriage, for example.
Okay, so it's more like holding individual shares that you can pass down separately. How does that stack up against joint tenancy, where I know that right of survivorship is the absolute key feature?
Joint tenancy is fundamentally different precisely because of that right of survivorship that's its defining feature. Here, two or more people are joint and equal owners of the same undivided interest in the property. And to create a valid joint tenancy, four specific conditions, called the four unities, must exist right from the start. 1. Unity of interest. All joint tenants must have the exact same equal share or interest. 2. Unity of title. They all must get their interest through the very same document, the same deed. 3. Unity of time. Their ownership interests must all begin at the exact same moment. 4. Unity of possession. They all must have the same right to possess and use the entire property. If even one of these four unities is missing when they try to create it, it usually ends up being a tenancy in common instead. The law is pretty strict about meeting all four.
And that right of survivorship, that's the real game changer here, isn't it? I mean, someone's share basically just vanishes from their potential heirs' point of view. What's a common mistake or misunderstanding agents see when clients don't fully grasp that?
Oh, it absolutely is the most important characteristic, and yeah, clients often misunderstand how it impacts their estate plans. If one joint tenant dies, the surviving joint tenant or tenants automatically become the owners of the entire property. It completely bypasses the deceased person's heirs or anyone named in their will regarding that property. This is powerful because property held in joint tenancy cannot be passed down through a will. If you die owning property as a joint tenant, your will has zero control over where that property goes. It's also not subject to intestate succession laws if you die without a will. And critically, it typically avoids the probate process altogether. That can save a ton of time, money, and public hassle for the estate. While deeds often say with right of survivorship for clarity, those words aren't technically necessary if the four unities are present. The common pitfall. Clients assume joint tenancy will achieve certain inheritance goals, but it actually overrides their will. Like your example, if Sarah and Tom owned as joint tenants and Sarah really wanted her share to go to their sister, but she died. Too bad for the sister, Tom automatically gets the whole thing, regardless of what Sarah's will says.
Wow, okay. So how do you actually create a joint tenancy then, according to California law? It sounds like you have to be pretty specific.
Yeah, California Civil Code Section 683 spells out the ways you can create one pretty clearly. It includes things like a transfer from a sole owner, maybe Tom, to himself and someone else like Sarah, specifically as joint tenants. Or if people already own as tenants in common, they can transfer it to themselves or to themselves and others as joint tenants. You can also transfer from existing joint tenants to themselves or some of them or others, which allows changes within an existing joint tenancy. A really common one is a transfer from a husband and wife, whether they hold it as community property or something else to themselves or themselves and others as joint tenants. This is often done specifically to avoid probate. Lastly, it can be created by a transfer to executors of an estate or trustees of a trust designated as joint tenants. The absolute key is the clear intention to create joint tenancy, spelled out in the deed or transfer document.
That makes it pretty flexible for setting up. But can a joint tenancy be broken? Can one joint tenant just decide to sever their interest, even if it messes up the ownership picture for everyone else?
Yes, surprisingly, a joint tenant can unilaterally sever their joint tenancy interest, often without even telling the other joint tenants, let alone getting their permission. This is usually done by simply transferring their interest to someone else, a third party, or even one of the other co-tenants. What happens next depends on how many joint tenants there were. Let's say Sarah, Tom, and their friend Maria own a vacation cabin as joint tenants. If Maria decides to sell her one-third interest to a new person, David, well, then Sarah and Tom would remain joint tenants with each other regarding their combined two-thirds interest. But David would own his one-third interest as a tenant in common with Sarah and Tom. David wouldn't have survivorship rights with Sarah or Tom.
Huh. So it changes the whole dynamic for that one share, but the original joint tenancy might continue between the remaining owners for their shares. What if there were only two joint tenants to start, just Sarah and Tom?
Good question. If it was just Sarah and Tom as joint tenants, and Tom transfers his interest to David, then Sarah and David automatically become tenants in common. The joint tenancy between Sarah and Tom is completely broken because one of the unity's title and time is now different for David. This really shows why understanding these details is so important for clients, especially when they're thinking about estate planning. A seemingly simple transfer can totally upend the survivorship rights, potentially destroying the main benefit they thought they had with joint tenancy.
Okay, let's shift to another crucial CA corner for anyone touching California real estate. Community property. This is unique to our state and just a handful of others. What exactly is it, and why is it so incredibly important for married couples like Sarah and Tom?
Right. California is one of only a few community property states, and yeah, this is a vital concept for married couples buying or owning property here. Generally speaking, community property includes all property that's acquired by a husband and wife or by either one of them during a valid marriage while they are living in California. The big exception here is separate property, which is treated completely differently. The core idea is that property earned or acquired through the efforts of either spouse during the marriage is considered equally owned by both spouses.
And what counts as separate property? Stuff that is not community property.
Separate property is defined as property that was acquired before the marriage, or property acquired during the marriage but specifically by gift, or as an individual heir getting an inheritance, or as a beneficiary named in someone's will, a divisé. It can also include property that the husband and wife specifically agree, in writing, will be separate property, like through a prenuptial or postnuptial agreement, or property designated as separate by a court order. The main point is, separate property, by definition, is not community property. It stays the individual property of the spouse who acquired it. Understanding this difference is absolutely critical for married couples in California real estate deals. It hugely impacts ownership rights, how property is divided if they divorce, and how it passes on death. For Sarah and Tom, this is a conversation they absolutely need to have, probably with legal counsel, to figure out the best way for them to hold title.
That's a massive one for anyone buying or selling with a spouse here. Before we move on from ownership types, let's quickly touch on the homestead exemption. What's its main goal and what's a common thing people get wrong about it?
The main purpose of the homestead exemption is pretty specific. It provides a limited shield for a homeowner's primary residence against certain kinds of creditors, typically general, unsecured creditors, whose claims might otherwise be enforced through judgment liens. It offers a level of protection, allowing a homeowner to keep a certain amount of equity in their main home safe from being forcibly sold to pay off certain debts. The common misunderstanding is that a homestead exemption protects you from all creditors or somehow lets you avoid foreclosure on your mortgage.
So it doesn't protect against the mortgage lender, for example, or property taxes.
No, absolutely not. And it's crucial not to confuse it with the property tax homeowner's exemption. That's a totally different benefit, the $7,000 reduction in taxable value for your owner-occupied home. Recording a homestead declaration, it has zero effect on your California property taxes. They are completely separate things. Furthermore, the homestead exemption does not stop foreclosure on voluntary liens like mortgages or deeds of trust. It doesn't protect against mechanics liens either, or things like child support or spousal support obligations. The real insight for you as an agent is knowing its specific, limited protection. It's often more about psychological comfort than a bulletproof financial shield. You need to guide your client's expectations realistically and prevent them from having a false sense of security about it.
This has been a fantastic rundown of ownership types. Now let's peel back another layer. When you look at a property, what are those unseen layers, those invisible claims that can really mess with ownership, even for Sarah and Tom's perfect dream home? We're talking about encumbrances.
Yeah, you've hit on a really critical point. This is where a dream home can turn into a nightmare if you're not careful. An encumbrance is basically a claim against a property made by someone who is not the owner. Think of it like a cloud hanging over the title, or maybe a hidden structural problem in a building. It's like a weight on the property that restricts its full free use or makes it harder to sell. While the owner still holds title, an encumbrance can seriously affect the property's transferability and limit how it can be used until that claim is dealt with. For instance, that dream of putting in a swimming pool might be impossible if there's a big utility easement running right through the middle of the backyard they didn't know about.
So these invisible claims can actually stick with the property even when it changes owners, meaning Sarah and Tom could inherit a problem they had no idea existed.
Absolutely. That's why it's so crucial for buyers like Sarah and Tom to be super aware of any potential encumbrances. They often do transfer with ownership. Failing to find and understand these things can lead to major headaches, unexpected costs, or even nasty legal fights down the road. This is why doing your homework due diligence is just paramount in real estate deals.
Okay, let's break down the different kinds of encumbrances, starting with an easement. What exactly is that?
An easement is basically one party's legal right to use or maybe even improve specific parts of another person's property. Or sometimes it's the right to prevent the owner from using or improving their own property in certain ways. Think of it as a limited right to access or use a piece of someone else's land for a specific reason. There are two main types. An affirmative easement lets a party use the property, like a utility company running a gas line across your yard, or people having the right to use a designated path on someone else's land.
And a negative easement. That sounds like stopping something.
Exactly. A negative easement gives one party the right to prevent certain actions on someone else's property. For example, your neighbor might have an agreement that stops you from building something tall that would block their sunlight or their view. Less common, maybe, but they definitely exist. Beyond that, easements can also be classified by who benefits. An easement in gross benefits a specific individual or a company rather than a piece of land. For instance, if the cable company has an easement to run lines across your property, that right belongs to the cable company itself, not to the property next door. It's usually not transferable, gets canceled if the owner moves or the company dissolves, and typically can't be passed on.
Okay, so it's personal to that person or company. What about an appurtenant easement? That sounds like it benefits the land itself, maybe.
You got it. An appurtenant easement is different. It happens when one party lets another use their property for a limited purpose, but this right benefits another specific property, not just an individual. The property that gets the benefit, that's called the dominant tenement estate. The property that allows the use, that's the servient tenement estate. So, if Sarah and Tom need to cross their neighbor's land to reach a public road and they have a legal right to do so, their property is the dominant one, the neighbor's is the servient one. This right attaches to the land and goes with it when it's sold. Common examples are easements of necessity, like for landlocked property, implied easements, based on how the land was used before, or the most common type, express easements, which are created by a written deed or contract and recorded. You also have prescriptive easements, which can actually arise from someone trespassing openly, continuously, and notoriously for a certain period, kind of like adverse possession, but just for use, not full ownership.
Wow, that's a lot of ways to get an easement, and clearly something you need to uncover. What about something like an encroachment?
An encroachment happens when a non-owner physically intrudes or interferes with someone else's property. The classic example. Your neighbor builds a fence, and it ends up being even a few inches over your property line. That's basically trespassing on your land. Or maybe a neighbor's big tree branches hang way over your yard, or the roots are cracking your driveway. That can be considered a nuisance and an encroachment. An encroachment creates an encumbrance on both properties until it's fixed. The property being encroached upon has its free use limited, and the owner doing the encroaching doesn't have clear title to the land their fence or building is sitting on. It's a surprisingly common source of neighborly disputes and something Sarah and Tom might easily miss just walking through.
And a lease is also considered an encumbrance. That makes sense, really, since it restricts the owner's use and possession quite a bit.
Precisely. A lease is just an agreement where someone rents a property for a set rate and time. While the landlord, the lessor, still holds the legal title, their ability to use their own property is significantly limited by that lease agreement because the tenant has the right to exclusive possession for the lease term. This restriction on the owner's ability to freely possess or sell the property makes a lease a significant encumbrance. Imagine Sarah and Tom buying an investment property only to find out after closing that there's a long-term lease in place they didn't know about. Big problem.
Next up, liens. These usually involve money owed, right? Giving a creditor some kind of claim against the property itself.
Yes, a lien is a really critical type of security interest that directly affects the property's title. It basically gives a claimant the right to seize the property or force its sale as collateral for some unmet obligation, usually an unpaid debt. The creditor can then have the property sold to get back at least some of what they're owed. There are several kinds. A tax lien is put on by the government for unpaid taxes, property taxes, income taxes, etc. In the U.S., for instance, a federal tax lien actually takes priority over almost all other claims on someone's assets, making it super powerful.
Okay, so taxes usually get paid first. What if, say, a contractor does work on a house but doesn't get paid?
That would typically lead to a mechanic's lien. That's a specific claim on real property made by someone who provided labor or materials for improvements but didn't get paid. Then you have judgment liens. These are general liens placed against a defendant's assets, including their real estate, after a court rules against them in a lawsuit and awards money damages. And probably the most common lien for the average homeowner is a mortgage, or more typically in California, a deed of trust. The lender, usually a bank, keeps an interest in the title until the loan is fully paid off if you don't pay. Well, that can lead to foreclosure, where the property is sold to pay back the debt.
And finally, restrictive covenants. These can get pretty specific about what you can and can't do, can't they?
Oh, definitely. A restrictive covenant is basically an agreement that a seller writes into the buyer's deed, or maybe into the main set of rules for a whole development. The CC&Rs, covenants, conditions, and restrictions. They restrict how the buyer can use the property. For example, a covenant might require you to keep the building's original facade, or tell you what color you're allowed to paint your house, or even ban certain types of businesses from operating there. As long as they don't break the law or discriminate unfairly, these covenants can be quite detailed, and they run with the land, meaning they bind all future owners too. For Sarah and Tom, this might mean, yeah, they can't paint their dream house bright purple, even if they own it free and clear.
This brings us nicely to our ethical compass segment. Given all these potential invivable claims, why is it so ethically vital for real estate agents to understand and disclose potential encumbrances to their clients? It seems like it goes beyond just being a good agent, doesn't it?
You're absolutely right. It really hits the core of ethical practice and professionalism. Being diligent about finding and explaining these claims. It isn't just about avoiding getting sued yourself. It prevents future heartaches and potentially huge financial problems for your buyer. Imagine Sarah and Tom finding out about a major undisclosed easement across their backyard after they've closed and already started planning their landscaping. That's a serious breach of trust. By being proactive, transparent, and knowledgeable, an agent protects their client's massive investment, builds a foundation of real trust, and shows integrity. It's about giving your clients the full picture so they can make truly informed decisions. And sellers, too, have a huge ethical and legal responsibility here. They must disclose all known material facts and defects about the property, including any encumbrances they know about. Trying to hide something, it's unethical and, frankly, usually pointless because a thorough title search will almost always uncover potential problems anyway.
That's a perfect transition to the importance of deeds in general. What exactly is a deed, and how does it function in this whole dance of transferring property?
The deed is really the cornerstone legal document in real estate. It's the instrument that formally transfers title ownership of real property from one person, the grantor, to another, the grantee. It only works when it's properly executed, delivered, and accepted. It's the physical proof that the bundle of rights is moving. This transfer can be voluntary, like in a normal sale or a gift, or it can be involuntary, like in a foreclosure or tax sale. But generally, without a properly executed deed, ownership can't legally pass.
Okay, so what are the absolute must-haves for a deed to be considered valid and legally binding here in California?
Right, for a deed to actually work and be legally effective, it has to meet several strict requirements. One, it absolutely must be in writing. You can't transfer real estate with just an oral agreement because of the statute of frauds. Two, the parties grantor and grantee must be properly described. They need to be competent to convey, like legal age, sound mind, and capable of receiving the property. Three, the property being transferred needs to be described well enough to clearly distinguish it from all other pieces of property. Usually this means a formal legal description, like meets and bounds or a lot and block number. A good description fits only that property. 4. There has to be a clear granting clause. These are the operative words showing intent to transfer, like I hereby grant, I convey, or I transfer. 5. The deed must be signed by the person or people making the transfer, the grantor. Their signature shows they intend to transfer it. 6. And finally, it has to be delivered by the grantor and accepted by the grantee. And this isn't just about physically handing it over, it involves crucial intent.
Are there things people might think are needed for a deed in California but actually aren't? Things that might surprise some folks.
Yes, definitely. For instance, that old-fashioned phrase, to have and to hold, which is called the habendum clause. It's often in old deeds, but it's not necessary for a valid California deed today. You also don't need witnesses to the signatures, nor is a formal seal required for the transfer to be valid. And while it's standard practice to date a deed, the day itself isn't strictly required for validity either, though it's obviously good practice for record keeping.
What about consideration? Like money changing hands. Is that essential for the deed itself to be valid?
Well, while consideration usually money, but it could be love and affection or other value is almost always involved in a property sale, it's not legally essential for the deed transfer itself to be valid in California between the grantor and grantee. You can gift property, and the deed is still perfectly valid between those two parties. However, and this is important, a lack of consideration can affect the grantee's rights against certain third parties. Why? Because recording laws are mainly designed to protect bona fide purchasers, people who paid real value and bought in good faith without knowing about prior claims. A gift deed, for instance, could potentially be thrown out by a court if it was made just to cheat creditors.
An acknowledgement. I see that on lots of legal documents where someone signs in front of a notary public. How important is that for a deed?
An acknowledgement is that formal declaration, usually before a notary, where the person signing confirms it's really their signature and their act. It's a really crucial safeguard against forgery and people pretending to be someone else. It adds a layer of authenticity. Now, while many documents must be acknowledged before they can be officially recorded in public records, a deed can still be valid between the grantor and grantee, and even between other parties who have actual knowledge of the transfer, even if it's not acknowledged. But, and this is key, without an acknowledgement, it generally cannot be recorded, which leads us right to the next critical point.
Which is recordation. Okay, why is recording a deed so vital if it doesn't actually affect the deed's validity between the original seller and buyer? That seems a bit counterintuitive.
This is a truly critical concept for protecting the buyer, the grantee, and one you absolutely need to grasp as an agent. While recording doesn't make the deed valid between the immediate parties, it's extremely important because it provides constructive notice to the entire world that the transfer happened. Think of it like posting a public announcement. If a grantee fails to record their deed, and then some other deed or document affecting the title gets recorded later by someone else, maybe the original grantor fraudulently sells it again, or a creditor files a judgment lien against the grantor, that first grantee is in serious trouble. In most situations, the priority of when something was recorded determines who has the superior rights if there are conflicting claims to the same piece of land.
So it's generally first in time, first in right when it comes to recording documents.
Generally, yes, under California's race notice recording statute. The document recorded first in the chain of title usually wins priority over later ones, especially if the later party didn't have actual notice or constructive notice from the recording of the first transfer. However, there can be exceptions like written subordination agreements or situations where the second party actually knew about an earlier unrecorded deal. Those facts can change the priority despite the recording dates. This also highlights why consistency of names in title documents is so crucial in the public record. You can't establish a clear record title unless the grantee's name in one document exactly matches the grantor's name in the next one. Any significant difference, like a typo or a missing middle initial, can make the title technically defective and might prevent that constructive notice to third parties, causing problems down the line.
What about delivery and acceptance? You said it's more than just physically handing over the paper. What's this intent part mean?
Right. The delivery part is often misunderstood. Delivery here means the grantor's intention to pass title right now, immediately and irrevocably. It's not just about the physical act of handing over the document. For instance, you could have a legal delivery even if the paper never changes hands, if the grantor clearly intends to transfer title and makes that intent known. Conversely, just handing over the deed isn't a legal delivery if the grantor doesn't intend for title to pass right. Then maybe they hand it over but say, "Don't record this until I die," and both parties believe it's not effective yet. In that case, title probably hasn't passed because the necessary present intent wasn't there.
So intentions really matter more than the physical act. If someone wants to transfer property, but only if certain conditions are met, What's the safest way to handle that in California?
Yeah, for conditional transfers, especially ones depending on future events, the best and safest way is either to physically hold on to the deed yourself until all conditions are met, or, much more securely, deposit the deed into escrow. You give the escrow company clear written instructions saying exactly what needs to happen before they can release the deed to the grantee. That removes all the ambiguity. Trying to deliver a deed directly to the grantee with verbal conditions? California courts usually treat that as an absolute, immediate transfer, unless those conditions are actually spelled out within the deed itself. And importantly, trying to use a regular deed that's only supposed to take effect upon the grantor's death, that doesn't work as a deed. It's seen as trying to make a will without following the proper legal steps for a will, so the property would likely have to go through probate anyway. That's why specific tools like the revocable transfer on death deed were created.
Okay, let's look at the different types of deeds we commonly see here in California. First up, the grant deed. What does that signify?
The grant deed is super common in California for transferring ownership or adding owners. When the word grant is used in the deed, the grantor implicitly warrants or promises two specific things, which gives the buyer some protection. First, they promise they haven't already transferred the same property to someone else. Second, they promise the property is free from any encumbrances, liens, taxes, etc., that were done, made, or suffered by the grantor, or anyone claiming under them. Basically, stuff they caused or allowed. Now, this didn't guarantee the grantor actually owns the property or that it's free from encumbrances they didn't cause, but it covers their own actions. It also automatically includes any appurtenant easements, and really importantly, it conveys after-acquired title. That means if the grantor later gets a better title to the property than they had when they first granted it, that better title automatically passes to the grantee.
Okay, so it gives the buyer some assurance about the seller's recent history with the property. What about a quitclaim deed? That name sounds like it offers less protection.
You're absolutely right. A quitclaim deed offers the least protection to the grantee. Why? Because the grantor using a quitclaim only transfers whatever interest they happen to have in the property at that moment, if any. There are zero implied warranties. It doesn't guarantee the grantor actually owns anything, and it does not convey any after-acquired title. Essentially, it says, look, I'm giving you whatever title I might have in this property, maybe none, maybe some, but I'm making absolutely no promises about it.
So why would anyone ever use a quitclaim deed then if it offers basically no guarantees?
Well, they're actually invaluable in certain specific, often critical situations. They're used all the time in divorces, for example. One spouse might quitclaim any potential community property interest in the house to the other spouse to make the title clear for them. They're also really common for clearing a cloud on title. That means fixing minor problems or ambiguities in the ownership history to make the title clean and marketable. Like if some distant relative's name pops up weirdly on an old record, getting a quitclaim deed from them can act like a legal erasure, cleaning up the title without the current seller having to warrant full ownership they might not technically have from that relative. It's often used for these quiet, necessary legal cleanups.
And what about a warranty deed? I thought those were pretty standard, but you mentioned they're rare here. Why is that?
Yeah, warranty deeds are very common in many other states. They contain express promises or covenants of title where the grantor basically guarantees the title and promises to defend the buyer against any future ownership claims or undisclosed problems. But they are, in fact, quite rare in California. The main reason is that here, that kind of comprehensive protection against title defects is almost always handled by title insurance. Title insurance provides a much more robust, institutionalized way to protect against title problems, making those express warranties in a deed largely unnecessary. And frankly, using a warranty deed here could just be confusing since the title company is already covering that risk.
That's a really good clarification for California practice. Now, a trust deed or deed of trust, this sounds super important, comes up with loans all the time. Does this one actually transfer ownership?
This is a huge point of confusion that trips up so many new agents. A trust deed, or deed of trust, is never used to transfer ownership, like in a sale. It is the functional equivalent of a mortgage here in California. It's a three-party security instrument. It temporarily transfers a bare legal title to the land over to a neutral third party, the trustee, purely as collateral for an obligation almost always repaying the loan. The borrower, called the trustor, keeps the equitable title and the right to possess the property. If the loan isn't repaid, the lender, the beneficiary, can tell the trustee to start foreclosure. It is completely, utterly distinct from a living trust, which is an estate planning tool for avoiding probate. They just share the word trust, but serve totally different purposes.
Okay, so it's a security instrument for a loan, not a way to buy or sell. What about a reconveyance deed? That sounds like it might be related to the trust deed.
You got it. Directly related. A reconveyance deed is the document that formally transfers that bare legal title back from the trustee to the trustor, the borrower, once the loan secured by the trust deed has been completely paid off. It basically signals that the debt is gone, the collateral is released, and that lien is cleared from the property title.
And a sheriff's deed, what's that about?
A sheriff's deed is what's given to the buyer after a property is sold at a foreclosure sale conducted by the sheriff, usually following a court judgment, like a mortgage foreclosure, or to satisfy a money judgment against the owner. The title you get with the sheriff's deed. It carries absolutely no warranties or promises from the sheriff's department. The buyer takes the property completely as is, regarding any potential title defects.
What about a gift deed? Seems pretty straightforward.
Yeah, a gift deed is simply when someone gives property to someone else as a gift using either a standard grant deed or maybe a quitclaim deed form. While the grantor might state love and affection as the reason, they don't legally need to state any monetary consideration for the deed to be valid between them. But, like we mentioned earlier, if a gift deed is made specifically with the intent to defraud creditors, it can be potentially set aside by a court if it leaves the person giving the gift insolvent.
And finally, a newer one here in California, the revocable transfer on death deed, or TOD deed. This sounds like a way to skip probate.
Exactly. This deed, introduced relatively recently in California, is specifically designed as a tool to leave real property directly to heirs without needing to go through probate court. The owner, grantor, names their intended heirs as beneficiaries right on the deed. The crucial part is, it has no effect while the grantor is alive, and they can revoke it any time. It only becomes effective upon the grantor's death. At that point, the beneficiaries can usually just record an affidavit of death to officially receive the property. It's a powerful tool for avoiding probate for a specific property, but it really needs to be done correctly with proper legal guidance.
Wow, so many different deeds and documents. Are there other types of recorded documents an agent might see that aren't exactly deeds but still affect title, especially maybe after someone passes away?
Oh, yes, definitely. Two very common and important ones, especially when dealing with deaths and co-ownership, are the affidavit of death of joint tenant. This is used to officially remove the name of a deceased joint tenant from the property title in the public records. It's crucial for clearing the title so the surviving joint tenant can sell or transfer the property later. The other common one is the affidavit of death of trustee. This is used to transfer property held in a trust into the name of the successor trustee after the original trustee dies. Both of these are vital for keeping the chain of title clear and accurate in the public records after a death, ensuring everyone knows who legally owns the property now.
This has been a ton of info about the legal docs and ownership structures as a real bedrock, like we said. Now let's talk about safeguarding the dream, the processes that protect buyers and sellers like Sarah and Tom, escrow, and title insurance. Let's start with the escrow process. You called it a neutral guardian. How does it work?
Escrow is absolutely essential in California real estate. You basically can't close a typical sale without it. In simple terms, it's a neutral third-party service, the stakeholder, or escrow agent, who holds onto all the money, all the documents, and all the instructions until every single specific condition agreed to by both the buyer and seller in their contract has been met. Its main job is to act as a fiduciary, making sure both sides meticulously do what they promise before the deal is finalized. It reduces risk, ensures fairness, and helps prevent arguments for everyone involved. Nothing really happens, nobody gets paid until escrow officially closes.
So the escrow agent is kind of like the unbiased referee of the whole transaction, making sure everyone plays by the rules.
You could say that, yeah, but maybe with even more responsibility. Their role is really multifaceted. They meticulously handle the money moving around, calculate and prorate things like taxes and fees, prepare and organize all the necessary legal paperwork, keep track of all the funds, and carefully process the whole transaction through to closing. They make sure everything strictly follows the contract terms and state rules. They don't work for the buyer or the seller. Their loyalty is really to the transaction itself, making sure it closes cleanly and correctly.
And in our CA corner, it's important to mention independent escrow providers, which are really common here. What makes them different, and why might agents suggest clients use them?
Right. Independent escrow providers in California are a specialized and highly regulated type of company. They're licensed by the California Department of Financial Protection and Innovation, used to be depth of corporations, which means they're under strict oversight and get audited regularly. This licensing means they are 100% neutral. Unlike some other setups, they can't have a financial stake in the deal beyond their escrow fee. Plus, they protect consumer funds through strong fidelity bonding of their trust accounts, adding an extra layer of security for the huge amounts of money involved. Their only business is escrow, so they're highly specialized experts in this critical process, providing unbiased expert service.
Okay, let's walk through the typical stages of a California escrow for Sarah and Tom's purchase. What happens right after their offer gets accepted and everyone's excited?
The very first real step is opening escrow. This usually happens super fast after the purchase agreement is signed by everyone. The buyer, Sarah and Tom, makes their earnest money deposit, often 1–2% of the purchase price, into the escrow account. This shows they're serious. At this early stage, the main documents, like the finalized escrow instructions and the purchase agreement itself, are also prepared and signed by both sides.
Then come the inspections, right? Usually kicks off in the first week or two.
Yes, typically within week 1+ of opening escrow, and usually spelled out as a contingency in the contract, the buyer starts scheduling those crucial inspections. This includes a thorough home inspection for physical problems, a termite inspection, often needed by the lender, and critically, the lender's appraisal to confirm the property's value for the loan. Sometimes environmental checks for mold, lead paint, or radon might be needed too, depending on the property. Getting these scheduled quickly is really key to keeping everything on track.
And if the inspections turn up problems, that often leads to repair negotiations, which I know can be a really sensitive stage.
Exactly. Usually around week 2, after the initial inspection reports come back, the buyer reviews them. If issues pop up, say, the roof is leaking or the heating system is ancient, they can submit a request for repair. This phase often involves a lot of back-and-forth negotiation between the buyer and seller to agree on how to handle those requests. Maybe the seller fixes it, maybe they offer a credit, maybe they lower the price. It can definitely be one of the trickiest parts of escrow.
And then often around day 17, based on the standard contract, comes the contingency removal.
Yeah.
That's a really big milestone.
Correct. By day 17, or whatever day is in the contract, buyers are typically expected to sign paperwork removing their major contingencies, like the inspection contingency, appraisal contingency, loan contingency. Removing contingencies signals that the buyer is satisfied with the property condition, they've got their financing locked down, and they are fully committed to buying the place. It's a huge step because usually after this point, their earnest money deposit becomes non-refundable, or at least much harder to get back if they try to back out without a valid reason.
As things get closer to the end, maybe around week 4, the buyer needs to nail down their funding.
That's right. Around week 4, the buyer finalizes all their loan details and makes sure all the lender's conditions are met. The appraisal coming in at value is absolutely crucial here, as it allows the lender to officially fund the loan. This is why getting pre-approved for a mortgage before even making offers is so vital for buyers like Sarah and Tom. It smooths out this whole funding stage and helps avoid last-minute panic.
And then just before the finish line, the buyer gets one last look, usually within 5 days of closing.
That's the final walkthrough. It's the buyer's last chance to double-check that the property is in the condition they agreed upon, that any promised repairs were actually done right, and that no new damage has happened since their first look. It's that last crucial check to make sure there are no unpleasant surprises right before closing day. Once all conditions are met by both sides, the transaction moves to the close of escrow. Ownership officially transfers, the money changes hands, and Sarah and Tom finally get their keys.
Okay, so we've talked through the ideal scenario. Let's switch to think like an agent, avoiding escrow fallout. Trulia apparently reported that a whopping 1 in 4 escrows falls apart. What are the common reasons deals die? And what can a proactive agent do to keep Sarah and Tom's dream alive?
Yeah, that's a sobering statistic, isn't it? It really shows why being proactive and a good problem solver is so important as an agent. One common reason is just buyer cold feet. As an agent, you can help mitigate this by keeping the contingency period efficient, not dragging it out. Work hard with both sides to resolve any issues found during inspections quickly before that initial excitement wears off and buyers start second-guessing. Sometimes connecting buyers with happy homeowners in the area or having past clients share positive stories can help reinforce the dream they're pursuing.
And what if the buyer can't actually get the loan? That sounds like a fundamental issue that should have been caught way earlier.
It is, and yes, it's a huge deal killer. A smart agent makes sure the buyer is solidly pre-qualified, or even better, fully pre-approved with a conditional loan commitment before they even write an offer, and you highlight that strength in the offer itself. It's also smart for buyers to maybe have a backup lender or explore options just in case something unexpected crops up with their first choice. Verifying the buyer's source of funds early, making sure the money is real, available, liquid, and properly sourced, is also critical to avoid 11th hour funding disasters.
What about inspection problems? Finding something scary during the home inspection, like asbestos, big foundation crack, major plumbing issues.
Yeah, those can definitely scare buyers and derail things fast because they mean unexpected costs and hassles. An experienced agent usually keeps a good list of reliable, reasonably priced contractors and specialists. Often, just getting a quick, fair estimate for the needed repairs can be enough to save the deal. It shows solutions, not just problems, and gives everyone concrete numbers to negotiate around. You have to be a problem solver, not just a bearer of bad news.
A low appraisal can also be a major roadblock, right? Especially in a hot market, or if the buyer's really pushing their budget.
Absolutely. While agents don't directly control the appraiser, they can be proactive. The lender should provide good support to the appraiser. And the listing agent should always be ready to meet the appraiser at the property, armed with solid, recent comparable sales data that strongly supports the agreed-upon price. Sometimes this preparation can help the appraisal come in where it needs to be, or at least provide strong grounds for an appeal if necessary.
And what if the buyer suddenly can't scrape together the full down payment, or maybe they get cagey and won't prove they actually have the funds after the offer is accepted?
This really goes back to that early, thorough qualification process. For down payments, you need to verify those funds are liquid and accessible with bank statements or proof of funds letters right up front. If a buyer is hesitant to show proof of funds, you need to figure out why early on. Is it a cultural difference, a privacy concern, or are they just playing games? Address it before you open escrow. Escrow shouldn't even start without being satisfied on this point. It's a non-negotiable financial requirement.
Lastly, what if the buyer tries to renegotiate at the very end, maybe even after contingencies are removed, essentially holding the seller hostage?
Ugh, yeah, this can be incredibly frustrating for sellers. And sometimes, unfortunately, it can be a tactic or even a cultural difference where contracts aren't viewed as absolutely final. A knowledgeable agent addresses this possibility head-on. Make it clear upfront to your clients, and if you represent the seller, communicate this firmly to the buyer's agent that requests for a renegotiation after the agreed contingency period ends will not be entertained.
Yeah.
You need to leverage that initial buyer commitment to make the contract as solid or airtight as possible and set firm expectations from day one. The agent's role here is all about proactive due diligence, constant communication with everyone, and expertly managing expectations to guide the deal smoothly to closing.
That's all a fantastic practical advice for agents trying to make sure every escrow actually closes. So once we've successfully navigated escrow, the next big shield for protecting ownership is title insurance. What exactly is it and why is it so necessary, even if someone's paying all cash?
Title insurance really is your ultimate shield, and yeah, it's pretty much indispensable, even for cash buyers. It's basically a contract that protects you against financial loss from defects in the title that existed before you bought the property. These could be things like undiscovered leaks, unknown easements, errors in public records, or even problems like fraud or forgery way back in the property's history. It also guarantees the lender's loan priority. Essentially, it ensures that the home you just bought is truly yours, free and clear of claims from the past that could challenge your ownership. It covers stuff like problems with previous ownership, undisclosed back taxes, claims by missing heirs you never knew existed, unrecorded easements, various encumbrances, and even fraud or forgery in past deeds. Even if you pay cash, it's highly recommended because it's your safety net against these unexpected, potentially devastating historical problems.
How is title insurance different from regular homeowners insurance? They sound kind of similar, but they protect against totally different things, right?
Yes, this is a super common point of confusion for clients, and it's vital for agents to explain it clearly. Title insurance protects against past defects and the title problems that happened before you bought the place related to its history. You pay a one-time premium for it when you close escrow, and that policy protects you, or your heirs, for as long as you own the property. And interestingly, in California, title insurance companies are actually not allowed to sell homeowners insurance. There's separate types of specialized insurers. Homeowners insurance, on the other hand, protects your house and belongings against future risks, things like fire, theft, vandalism, certain natural disasters, or liability if someone gets hurt on your property. You pay premiums for this regularly, usually monthly, quarterly, or annually. So think of it like this. Title insurance looks backward to protect your ownership history, while homeowners insurance looks forward to protect your property from future damage or loss.
Are there different kinds of title insurance policies in California that Sarah and Tom might come across?
Yes. There are two main types you'll deal with in California. First is the owner's policy. This protects you, the property owner, Sarah and Tom in this case, from covered title problems. In California, there are two main flavors of owner's policies. The CLTA, California Land Title Association policy, which is the standard basic coverage policy, and the LTA, American Land Title Association policy, which offers broader extended coverage for a higher premium. The LTA policy covers additional off-record risks like unrecorded easements or issues with property access. It's often used for commercial deals, vacant land, or by lenders who want extra assurance, but homeowners can buy it too if they want maximum protection.
Okay, and the second main type of policy.
The second is the lender's policy. This is totally separate from the owner's policy. It's specifically designed to ensure the lender's financial interest in the property. It makes sure the lender's loan gets paid back first if there's a foreclosure or other title claim. Critically, a lender's policy does not protect the buyer or owner at all. It only protects the bank or financial institution that gave the loan. Your lender will almost certainly require you to buy this policy as a condition of giving you the mortgage, and the cost is usually paid by the buyer.
How much does title insurance usually cost in California, and who typically pays for it? I know that can vary depending on where you are.
Right. The cost depends on the property's value and the specific policy coverage. But generally, it ranges from maybe $2.70 to $3.50 per $1,000 of the property value. So for a $750,000 house, the owner's policy might cost somewhere between $2,000 and $2,600 roughly. Now, who pays for the owner's policy in California? That's a fascinating quirk because it's determined entirely by local custom, not by state law. In Southern California, traditionally, the seller pays for the owner's policy. But up in Northern California, it's typically the buyer who covers this cost. It's a key negotiating point to clarify in the purchase agreement. The ALTA lender's policy, though, that's almost always paid by the buyer no matter where they are in the state because it's a requirement for their loan.
And how do title companies figure out if there are problems before they agree to insure the title? Do they just kind of guess?
Oh, absolutely not. Before they issue any policy, title companies conduct a very extensive and careful title search. They meticulously dig through public records, county recorder's office, tax agencies, court records, sometimes going back decades. They're looking for any existing listeners, claims, encumbrances, or defects in the ownership history, the chain of title. Their goal is to ensure the property has marketable title, meaning it's clear of problems that could affect ownership or make it hard to sell later. This thorough search is how they figure out the risks involved. If they find a problem, they'll either require it to be fixed before closing, or they'll list it as an exception on the policy, meaning the policy won't cover that specific known issue.
This has been incredibly thorough, wow. From the history of property rights all the way to the nitty-gritty of deeds and the safety nets of escrow and title insurance. Let's wrap up with Adapt and Connect, empowering your practice. How does knowing all this foundational stuff truly empower a real estate professional to better serve clients like Sarah and Tom?
Well, having a deep, really nuanced understanding of these fundamental property concepts, it elevates you. It transforms you from just a transactional agent into an invaluable, trusted advisor. It lets you confidently navigate really complex deals, anticipate potential problems before they happen, give insightful, accurate advice to your clients, and ultimately build much stronger, trust-based relationships. When you can clearly explain why a specific deed is being used or how an easement might affect their future building plans, you're not just spitting out facts, you're actively safeguarding your client's investment and their peace of mind. You become more than just a salesperson. You become a genuine expert, a guide, and a problem solver for them.
So, knowing about the bundle of rights, the difference between real and personal property, the details of ownership types like joint tenancy versus community property, spotting those invisible encumbrances, and understanding the crucial protections of escrow and title insurance. It all empowers agents to be proactive, to solve problems, make the whole stressful process smoother and safer for everyone. It builds confidence, not just for the agent, but really importantly for the clients too.
Exactly. It really boils down to preparedness, professionalism, and ultimately providing a superior level of service.
Okay, so to bring it all together for ensuring a smooth escrow and making sure you're protecting your clients and yourself, remember these key tips. First, always work with a licensed realtor. They're bound by a code of ethics and professional standards. Second, choose a licensed independent escrow provider, especially here in California. Remember, they're 100% neutral and have bonded funds for protection.
For sellers, eliminate those surprises. Proactively disclose everything you know that's materially wrong with the property, including past problems or repairs. Have your valid government ID ready for the notary you'll need it. And if you're in an HOA, get all that info management contact, dues, payment methods to escrow early.
Buyers, you need to eliminate surprises too. Deal with any potential credit issues early by getting pre-qualified or, better yet, fully pre-approved before you start making offers. Be super responsive to requests from the escrow officer and show up promptly for signings with your valid ID. And make sure you sort out your homeowner's insurance early. Your lender will require proof of it before closing, and getting a policy can sometimes take a little time.
Finally, for everyone involved, complete all your walkthroughs and contingency removals on schedule inspections, termite reports, checking permits. Delays here are a major reason deals fall apart. And maybe most importantly, cooperate and communicate. Keep things moving. Real estate deals involve a lot of people, and quick responses and a positive, collaborative attitude really do encourage a smoother closing for everyone. Don't be the bottleneck.
All right, let's quickly recap our deep dive today into the absolute foundations of property ownership. Real versus personal property. We learned it's way more than just the deed. It's about what's truly part of the land, immovable, a fixed, a pertinent, versus what's movable. And that difference impacts contracts, taxes, and legal rights in huge ways. Ownership styles. Understanding sole ownership, tenancy in common, joint tenancy, and especially California's unique community property laws is critical. It dictates things like survivorship rights, whether probate is needed, and how property gets divided for your clients. Invisible claims. Encumbrances like easements, liens, and restrictive covenants. They're fundamental to property rights. They can seriously impact how a property is used and sold, highlighting why a thorough title search and title insurance are absolutely essential. The escrow safety net. Escrow acts as that indispensable neutral third party for a secure deal, carefully managing money and documents according to the contract. And title insurance provides that vital protection against hidden claims from the property's past, safeguarding your client's biggest investment.
This knowledge really is the foundation you build everything else on. In our next deep dive, we'll actually shift gears from these core concepts to the dynamic world of listing agreements and purchase contracts right here in California. We'll explore the agent's role in those, the nuances of different agreements, and how to really master the art of the offer and counteroffer.
That wraps up another deep dive into the fascinating and sometimes complex world of California real estate. We really hope you feel more empowered and confident now in understanding the very bedrock of property ownership. Remember, this knowledge isn't just to pass the test, it's what makes you an indispensable, ethical, and truly successful guide for your clients.
Keep reviewing your notes, maybe practice applying some of these concepts to scenarios, and just never stop digging for more knowledge. Join us for our next deep dive, and hey, if you found this valuable, please share it with another aspiring agent you know.
And here's a final thought to chew on. As you navigate this exciting real estate journey, remember that every single property, no matter how grand or how modest, carries more than just a deed. It carries a history, a complex web of rights, and often these unseen claims that only the truly well-informed professional can decipher. Your ability to uncover and understand all these layers, that's what truly transforms you from just a salesperson into a trusted advisor, helping build dreams one well-informed step at a time.